Hi, my name is Wiebe Hommes and I would like to begin by asking you a question. Do you know where your fundamental rights protection comes from? Most people might say, well, maybe, well, that's the Constitution. Whereas actually, it's a European document, a European Convention on Human Rights. So how did a European document came to safeguard your fundamental rights? To answer that question, I would like to draw your attention to this headline of 1976. And it says, European Court rules in favor of soldiers. Now this headline is important for two reasons. First of all, it was the very first time the Netherlands was convicted by the European Court for a violation of human rights. And secondly, this case stood at the beginning of a revolutionary development which turned the European Convention, which was very little known at the time, into the most prominent legal tool for human rights protection. So why did that happen? Scholars have drawn up the image of a sleeping beauty, the Convention, being kissed awake by a prince in the mid-70s. And as telling as that image is, also some questions surrounding it. Who is this prince? And was the princess always like that? Asleep? Beautiful? Now those are some of the questions I take up in my research, which is a reception history of the European Convention in the context of the Netherlands from 1945 until now. And by reception history, I mean how international law is received in a domestic context and shaped and given meaning by a variety of actors. So not just the courts, but also diplomats, activists and scholars. And in doing so, I hope to write a new story and show how the story of the Convention is not a passive evolutionary tale, but rather an active story of man-made development in which choices were being made. And I aim to uncover those choices. Now I think it matters to write this story, because only if we understand the past can we meaningfully engage with present-day questions. To study the past is to unlock the prison of the present. So if we take the prince as not being a singular court, but a variety of actors, we can much better deal with present-day criticism of the court. And secondly, if we want to understand the unequal application of human rights throughout the Kingdom of the Netherlands, we need to take into account the long colonial legacy, as it was also enshrined by the Convention in the 50s and 60s. The story I would like to write, and the image I would like to leave you with, is not that of a sleeping beauty, of a much more active engagement with the Convention and its audiences. So, the princess and the prince dancing together towards a possibly brighter future.